dear audience, welcome to 2021 World Intellectual Property Forum, the online virtual conference. I'm the moderator, Professor Mei-Hsin Wang from National University of Science and Technology, Taiwan. I'm the Fellow Royal Society of Chemistry, UK. I'm here for the panel titled Controversy and Friend for Standard Essential Pattern Codes. In this panel, we are very honored to have Sir Christopher Floyd, the former Lord Justice of Appeal, UK Court of Appeal, England Wales, Honorary Professor of Law from University College London, and Professor Randall Rader, the former Chief Judge of United States Court of Appeal for the Federal Circuit and the Rader Group. Professor George Thomas Lloyd, the presiding judge of Germany Federal Patent Court, and Dr. Joseph Kim, the former Chief Presiding Administrative Judge, IPTAP, Korea Intellectual Property Offices, to share their views on the panel titled Controversy and Friend for Standard Essential Patent Code. Our next speaker is the former Chief Judge from United States Court of Appeal for the Federal Circuit, Professor Randall Rader. Professor Rader, would you mind kindly share the current controversy on SEP and FRAND in United States?
Thank you very much, Professor. This is indeed a very fascinating time in our international intellectual property system. And it is important to recognize as my first theme that the intellectual property system is indeed international. You cannot adequately protect your intellectual property by remaining just within your own national borders. Technology knows no borders, and thus protection of that technology must extend far beyond your own borders. That leads to an interesting paradox, because enforcement systems are all national. They are limited to the extent of one nation's borders. And yet, as I expressed, the technology is not limited by those borders, and the protection must go beyond those borders as well. And that creates a very difficult and challenging problem of enforcement beyond your own national borders. That is even more difficult in the area of standard essential patents, where, of course, the standard as well as the technology extends beyond borders, and therefore enforcement of those standard essential patents must be of an international character, yet pursued often in a national forum. We're all aware that in the Unwired Planet case, one nation, the United Kingdom, said, we will be happy to accept these standard essential patent cases and give as a remedy an injunctive relief that will only be withdrawn if there is an international license. Well, this poses some difficulties because the international license, even if it can be enforced with an injunction within one nation's borders, even if that is possible, and I have some qualms about that, the international license would have to be different in different marketplaces. A technology does not cost the same in China as it does in India, as it does in Brazil, as it does in other markets and nations. And so each market really needs its own separate determination. That leads to, of course, the problem of national enforcement to achieve those proper market compensations in different locations, but without impacting other markets. All of this theoretical conversation really gets us to the point of anti-suit injunctions. If you sue in your own home country to set a licensed rate for the standard essential technology in that location, the automatic result is that the other party will file in their home country or in a different location at least, and in a different market, seeking a different rate. And as those two national courts confront each other, often the result has been an effort to enjoin that competitive rate setting institution. To use the most recent example, you had, well, let's use a hypothetical example. You could have a Chinese company who may wish to sue in Shenzhen or Wuhan or Beijing to set the rate for the use of the standard essential technology. They may be suing an American company, and the American company may say, we would prefer to set the rate here in the Eastern District of Texas or the Northern District of California, U.S. courts. And in several instances, we've had the Chinese court, Wuhan or Shenzhen, enjoining the activities of the parties to enforce their judgment in another locality, in California or Texas. We've had the same result in California and Texas, where the courts there have enjoined any enforcement activity on the same technology and the same patents in China or other locales. I think this is leading to a conflict between these courts as one court tries to rush to be the first. Timing becomes important sometimes. Which court first had the case, which court first filed the injunction. And so there's a race to be the first court to be handling it. All of this sacrifices the doctrine of comity. Comity is a doctrine which suggests that courts should respect each other's jurisdiction and, if possible, defer and let another court handle their national cases while you are handling your national cases. Of course, the problem here is it's the same case with the same patent and the same technology. We, of course, have the problem that if the Texas court, for instance, does not stop an enforcement action in China or Japan, then the case in Texas may be prejudiced because the parties will be forced to settle before the case can be fully heard, forced by the prospect of a punitive injunction in their in the other forum, the Chinese or the Japanese forum. Well, there are some potential solutions. I tend to think the best solution is a arbitration proceeding where the parties consent to select their own judges. By the way, I have done several of these arbitrations in the standard essential patent area, where the parties can select their own panel of judges and submit the entire international dispute to one forum and one resolution. That's very convenient. Now, it's criticized sometimes because the arbitration tribunal, of course, does not have the power to invalidate a patent. They can, of course, weigh the principles of validity and refuse to grant any weight to patents that they perceive are likely to be invalid. So validity plays a very important role in an arbitration proceeding. But the party who is implementing the technology loses the threat that we will invalidate your patent if you go forward with too high a royalty rate for use of the technology. I have found, by the way, that the tribunal, the arbitration tribunal, can, by taking into consideration validity, negate the problems of that I'm suggesting. But it's nonetheless a factor which weighs into this consideration. An alternative outside of the parties agreeing to arbitration may be some effort to recognize that each jurisdiction has its own authority to resolve disputes for their own marketplace. And so if there is some way that the courts can acknowledge an expanded comity doctrine that will not compromise another court's ability to resolve its dispute in its market while achieving a result within their market. In other words, the Chinese or Japanese court could resolve the issue expressly stating that they are doing it just for the market within their control. And the Texas and California courts could do the same. Now, this has the same problem, however, as the validity concerns in the arbitration situation, meaning that the patent owner is losing leverage to impose its royalty worldwide and thus obtain a settlement on a better basis. And so it shifts the difficulties of it compromises the leverage which a party would otherwise have if their local proceeding could have an international impact. Well, this is a subject we could discuss, Professor, for many months, and we could discuss the various cases that have implemented these procedures and the conflicts between Chinese and American courts and allegations that one court system is better or worse, or more available or less available, or the first or the second place of filing. In sum, none of these arguments are really the key. The key is going to be some kind of agreement amongst the users of this system, the large international companies, that they are going to submit their disputes either to a single forum where all international issues will be resolved at one time, or that they will accept an adjudication of their international dispute in different places, in different markets, and under the rules of different national systems. I find that quite inefficient and expensive, but there are at least some of the issues, Professor, that need to be dealt with in the area of international enforcement of standard essential patents.
Thank you, sir, for sharing your view on FRAND and SEP in United States. And you also kindly offer an alternative for arbitration to deal with the patent dispute. May you kindly give us more specific about the process, how the mediation arbitration will be taken place?
Professor, you asked me to discuss how a mediation might go forward in the standard essential patent area. Mediation, of course, is a procedure which brings the parties together in an effort to settle the case without full litigation. I have done several mediations. They begin with each party submitting a statement of 20 or 30 pages to the mediator, and I acquaint myself with the facts of the case. Then we schedule a meeting. We are all together on Zoom, usually, this kind of a medium. I give a speech, which I won't repeat here at the beginning. In the basic points of the speech are that they need to genuinely seek to understand the other party's interests and their genuine needs. I then break them into two separate rooms, and I go to each party in succession. I discuss the strengths and weaknesses of their case. I discuss the great costs of proceeding with litigation, particularly if that litigation is going to be in 4 or 5 or 6 different nations. And I acquaint them with how they will have to send their corporate executives from one court to another, and how that disrupts their business. And then I try to encourage them to see a path towards a settlement. Now, the key often comes when we start putting numbers on the whole process. And the numbers can start with the mediator. The mediator often will give his assessment. I would give my assessment of what I think the value of the case is to each party, or I encourage them to do that. And then I take that starting point, and of course one party will say it's much too low and the other party will say it's much too high. I will point out that well, they have to take this into consideration, And when they do, that number will come down or go up. And over a period of many hours, usually, I have done a mediation that went for 30 hours continuously, no sleep. But we achieved our result. And the parties settled the case. And they came to a royalty payment in terms of a percentage of the revenue generated by the patented product. And both parties were happy with that. And we reached the result around the 22nd or 23rd hour, but it took many more hours to reduce that to legal language. One party would propose a paragraph, and the other party would amend it, and we'd go back and forth for many hours. But that achieved its result, and in 2 days, or a day and a half, we had a resolution that, if the parties had litigated, would have taken them months and years and perhaps millions of dollars in expenses. Does that help, Professor?
Oh, yes, very much. And I think they help industry to understand how the mediation will go and the process of preparation and the benefits they can receive. So I think this is a very good experience sharing. Thank you very much, Your Honor. We hope we will have another opportunity to invite you to share more insight experiences. Thank you for helping the industry for your whole life. You have been teaching internationally for student industry and guiding many countries for their policies. You are a genius, you are a legend. Thank you very much again. Thank you for sharing.